Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Always down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, 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 everybody. Miss Vicky, thank you so much. I don't know quite how this have both happened, but I'm going to say thank you twice. Twice, I said. Anyways, I hope that everybody's doing well today. It is indeed Tuesday, Taco Tuesday. I made a bit of a boo-boo, as I alluded to earlier. Pardon me. One day you'll understand what the lady's saying. It's about a girl on top, Lisa. I know the lyrics. Anyway, so I made a boo-boo, but that's okay. We're going to move along. I have to drink a special edition Coke, I think. I think it's a regular Coke. It's original taste. Goût original. But it's got that dude on the front. Oh, there's a lot of lights in here. So anyways, and I have it in a special mug with lots of ice. I don't know if you can see all the ice in there yet, but I'm about to pour that. It's a boo-boo. A mistake. A problemo. Holy shit. Courtney. So like a boo-boo would be Courtney not realizing that the taco stand was closed. Although if it wasn't meant to be closed, that's not really a boo-boo on your side. Here's what happened, what my boo-boo was. Uh-oh, losing power on and off. Be careful, Wahoo. I love that 12 string. Let me just, okay, so most of my pop is in my drink, in my cup, which is great news. What was I going to say? It's always closed Sunday and Monday, but not Tuesday. Well, where I am, it was a holiday Monday. So that means that things that would normally be closed on a Sunday, Monday would get an extra day off the Tuesday, because that's just their regular days off. So maybe they're Canadian. Maybe they're celebrating Canada. What was it? It was Victoria Day this weekend, I believe. I, again, don't experience holidays the same way as I used to since working online more. So I don't really get long weekends the same way anymore. But that's okay because I also set my own schedule. So, you know, you take some, you win some, you lose some. Bye, Mayor. We love you. We are always thinking about you. And you're always working so hard. Good Mayor. Okay. I was in a bit of a bad mood earlier. Because I don't really know why, to be honest, but I was. But I snapped myself out of it. And then I realized this is my first coffee of the day. It is almost full. So that's probably why I'm not in a great mood. And then, but I don't know why I didn't drink it today. Why wasn't it good today? I don't know. That's something we'll have to look into later. We'll have to ponder. Anyway, so originally I had a video from, well, I still have the video, but it the first 2 videos are in 2x speed, and it was taking me a really long time to slow it down, so I only got one of them slowed down. So we're not gonna watch that video till tomorrow. Tomorrow is gonna be, it's a pretty interesting case with referee Kmetz, Kmetz. He's what I often call the funny judge or the joking judge, but he also sometimes is like weirdly inappropriate. You know what I mean? I know my blood caffeine levels. Well, I'll be honest, I did have a Coke earlier today. I don't know what happened with the coffee. I don't know. We're just going to reset tomorrow. That's what we're going to do. Reset tomorrow. Yeah. Also the weather, the barometric, like the weather has changed here. I'm still a little bit sick. Cough for effect. Thank you. This is my new favorite shirt. I love this shirt. Thank you to the person who bought me this shirt. Hi, Lucy. Anyways, so we'll deal with Kmetz tomorrow. It's like an hour-long case that we have, and he gets real. It's a cock block. He doesn't give us a ruling, but he's real snappy with the lawyer. I'll say that. I will say that. But today what we have is some of Judge Kirkham and Coca-Cola with ice. Any recent earthquakes? There's always earthquakes around here. I would have to literally look and see if there was earthquakes. Let's see. It's part of when I'm OG for Angle Bay. Latest earthquakes. Thank you so much, Chris. OG forever. There's been some in Alaska. I mean, there's like hundreds. There's one in Oregon, a 3.1, 10 kilometers off of Oregon. I feel ya, Lori. I feel ya. I've snapped myself out of it a little bit. Here's the thing. Making your own tacos versus eating other tacos, not the same, but I get it. I can't afford to go out to eat tacos right now. Tacos are not cheap here. I'm trying to do my best to cook my own. And so I'm going to make not slow cooker, the Instant Pot chicken with my mild chili seasoning that I got at Walmart. I love this chili seasoning. I bought it for a different recipe, and I have been using it on all my Mexican foods, all of them, including like if I make a quesadilla, sprinkle. I even put it on grilled cheese the other day, you guys. Grilled cheese. Yeah, this is good. Cellulite Yoga Pants. Tell us about it. Tell us about your good day while we go and see some people probably not having a good day because they're in court. Pretending pretzels are tacos is a good idea. Yeah. I didn't make my strawberry dessert yesterday, but I'm going to make it today. But I have to do this first. And then I'm going to do it. Uh-oh. Wahoo's got the power down. Be careful. And Chris coming through with the taco fund. I love you, my friend. Do. OG forever. Amazing. Yeah, much more meat on the homemade tacos. That's true. This is true. And Bill, I heard that today. Tacos are now considered sandwiches. If you don't know what we're talking about, go ahead and check out an extremely short version of We Gotta Chase today, featuring Creed only. Yeah, I did see that Ryan Hall was live, so obviously weather alerts and all. The temperature here today is 54 degrees right now. Cloudy conditions will continue for the rest of the day, with wind gusts up to 37 kilometers an hour. Yes. I know. I love Ryan Hall, y'all, too. I love Ryan Hall, y'all, and how Hall, y'all, great he's doing. It's great. Oh, enchiladas are another really good recipe that I have that this taco seasoning will be really good for, Lisa. It is I love enchiladas. They're so yummy. And if I go to the local enchilada place, I guess the Mexican restaurant, it would be like, for 3 enchiladas, I think would be $12, which is quite a lot. Sorry, I hear somebody outside my house. I'm gonna have to play.
I had a little technical difficulties, so let me get. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-3267 DP LaShawn Young versus Frederick Hunter. Today is Monday, May 20th, 2024 at 10:37 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This is before the court on the front of the court's motion to show cause. Mr. Magnuson.
Thank you. The court is correct, and I think the pleadings in the file speak for themselves. We did serve Ms. Young with the order to show cause per the court's order. Judge, we're simply asking for compliance. We have a request and actually an order for genetic testing. Ms. Young just needs to comply with that order. That's all we're seeking.
Okay, Ms. Young, you're muted. You'll have to unmute yourself, lower left-hand corner of your screen, and then you can talk to us.
Sorry.
Please unmute.
Please
I spoke to her
unmute.
earlier.
Yeah.
Please unmute.
Ms. Young, you have to unmute. You have to hit the microphone in the lower left-hand corner of your screen so you can talk to us.
I'll chat with her, but I talked to her earlier, so.
Well, it looks like she's frozen now.
A Creed frame. Boom, boom, ba-doom, ba-dum, a Creed frame.
All right, let me bring someone else in just to check them in. LaShawn? Please unmute LaShawn. Rebecca, your first and last name, please. Oh,
You're
please
muted.
unmute.
I'm sorry, Rebecca Hamilton.
All right, Rebecca, I'm gonna place you in the waiting room, okay? I'll bring you in as soon as we're ready to call your case. Please do not disconnect.
Okay.
Thank you.
Ms. Young, Mr. Magnuson stated that you were ordered to participate in the genetic testing. You did not. Why is that?
Marshawn ain't here. Marshawn been gone since February.
Okay, well, where is the child?
He left and I don't know where he is. He contacted me on Facebook Messenger.
Excuse me, what? This is a bigger problem. Oh my God. That's terrible. How old is this child? Oh my goodness. Jesus Christ. Now tacos, apparently her tacos ain't so good. That's a bad joke. It's a terrible joke. But why is the child, where's the child? Since February, this is in May. February, March, April, May, 3 months. She better have reported him to the police.
Okay. Mr. Magnuson, what are your thoughts?
Well, this is my first time hearing this. Is Ms.
Do
Young?
you know, is there any other benefits being paid for on behalf of the child?
Well, that was my thought, Your Honor. That was something to look into. If this is the case, is Ms. Young indicating that the child no longer lives with her?
Nope. He decided he wanted to leave and move.
Okay, but he's not living with you.
Nope. So I don't get no benefits or nothing for him.
Okay. Well, again, thoughts then, Mr. Magnuson?
Well, I suppose we could adjourn this matter and allow us to look into this. Again, this is my first time hearing about this.
Okay.
So I
Why
think
don't
it's
we
worth-
adjourn it, set it without date, and then you can renotice it if whatever you find out, Mr. Magnuson. But my intent is if there were any benefits being paid, is to suspend those until such time as cooperation. But if
Right.
the child is taken off, then
Right.
it'll be something else we have to do.
Right. We'll look into
Okay.
it, Your Honor.
Okay. Thank you. Thank you both. You're free to go. Have a good day.
Thanks, you too.
Thank you.
I'm sorry. What is happening right now? I am beyond fucking floored by this. You're going to tell me that in 3 months she called and got benefits stopped? I don't think so. I don't think so. I'm actually having a hard time with this case. I'm really flabbergasted too. I'm like, is it because I'm just so confused. Colin, thanks for being here, friend. We're just dissecting what just happened. Now, is the child missing or did the child leave? And are you allowed to let a child leave? And if they leave, like, all of this seems very suspect. Plot twist. There never was a kid. Wahoo, be safe. Everybody who may be in the face of a storm, first of all, say, fuck you, storm. You don't run my life, but then say, yes, you do, and go to your safe place, okay? That's what we do. Yeah, phone calls are starting immediately. I'm fucking floored here. Like, would this be a good case for an ad litem? Right? Nobody mentioned how old the kid is. I'm assuming old enough that this is not as weird, but I'm very, very, very concerned. This is not the 1990s when parents used to get a 10 o'clock message or 9 o'clock message. Like, it's 9 p.m. Do you know where your kids are? Like, that was not a joke. That was a literal reminder to parents. Like, yo, kids should be home by now. Are they home by now? This mom got like She went through spring break, no kid. She went through Easter, no kid. She went through yeah, this is terrible. Terrible. That would be terrible. Terrible. Hate Casey Anthony so much. I was scarred by that trial. I watched every minute of it every single day. And I was fucked up by that case. This is giving me weird vibes. Like, why wouldn't the court be is the court not a mandated reporter? Are lawyers not mandated reporters? Kids, do you know where your parents are? That's funny too. I guess. I mean, I'm not. But again, Cellulite Yoga Pants, your oldest is old. No offense.
All right, Niels, I'll call your next case. I don't have, let's see, this is Rocket versus Wright. I do not have plaintiff or defendant present in my waiting room, and you did indicate that it said PM.
It did on this one on Rocket, the order said 10:30 p.m.
Yeah.
So
Yeah, we can't proceed if
Hold on. They sent the notice for 10:30 p.m. What the fuck is happening in this court today? What is happening? God damn. I'm still really fucking flabbergasted at that last case. They didn't even set a date certain. Jeez.
the notice is wrong, just get it renoticed.
we'll
and-
reset it.
Yeah.
All right,
Okay,
thank you.
thank you.
Okay, so I do have Rebecca Hamilton and Amari Carter are both present. Amari? Please
But what
unmute
about-
Amari.
What about a court? Somebody on this call should be a mandated reporter. Also, it's not her attorney, it's her ex's attorney. So I wonder what the rules are of that. Like, I guess you don't have to be a mandated reporter to be a reporter. She says.
Yes, ma'am.
All right, calling case 2014-615 DS, Rebecca Hamilton versus Amari Carter. Today is Monday, May 20th, 2024 at 10:43 a.m.
This matter is before the court on the plaintiff's motion to set aside referee order.
Tracy, we are so glad to see you. Oh my goodness, love it. It just seems to me, I don't know if you heard this, but the case before here, the lady was the kid's been gone since February. Seems weird. My glasses are props, so I don't know about the oversized glasses. But I've said this before and I'll say it again. As you can see, mine don't have lenses in them because I have actually been blessed with better than perfect vision. Yeah, that's right. Better than perfect. And better than perfect hearing. But I like having props to make me match people that are on the screen.
Ms. Hamilton, you stated, and I quote, "I want to change custody of Amani Carter," end quote. What happens to set aside a referee recommendation? You have to show that the referee made a factual or legal error, not that you want something different than what, again, he may have ordered.
Yes, so this hearing is to change for Amani, but we tried her coming over here and it hasn't gotten any better. It's gotten worse. So, and I didn't want to just not show up and be held contempt of in court. So that's why I showed up. So that we're not changing the custody order. So what do I have to do in order to change custody for the other 4? So they're with me full time.
Well, you're going to have to file a motion. You have to file a motion for custody. You have to set forth the factual basis and the legal
Okay.
basis as to why you should have custody. And
Okay.
then the defendant would have an opportunity to respond and basically challenge or contest whatever you said.
Okay.
Okay? But as
Okay.
to setting aside the referee, you haven't set forth a sufficient basis to do that.
Right. This is new to me. I'm not really, so I'm gonna go to the courts today to file a new motion and do it.
They're both wearing tank tops in court. You guys. Tank tops in court. Oh my God. What is going on with this court today? I know why she's wearing this, so that she can show off that tattoo. But if you want to show off your tattoo, you got to put it somewhere else. You cannot fucking put it there. I know. I wish I was like Mikey and had graphics that I could use midway and be like, versus. They are twinsies, right?
Proper way.
Okay.
Thank you so much.
With that, the court will deny it. So, Mr. Carter, you don't have to do anything. We're denying her motion. And then she can refile another motion, a different motion, if she wishes to do so. Okay?
Yes, sir.
Okay.
Yes, sir.
Thank you. You're free to go. Have a good day.
You too.
All right, I'm gonna bring in Attorney Thomas.
Fucking
I
Lincoln.
do not have Shania Krakoff or Nathaniel Weatherall in my waiting room. Calling case 2022-857DS, Shania Krakoff versus Nathaniel Weatherall. Today is Monday, May 20th, 2024 at 10:45 a.m.
Court will note the appearance of Ms. Thomas on behalf of the interveners. This matter was brought by the plaintiff on a motion to set aside the referee recommendation. It was set for 10:30 a.m. It is now 10:45. As a result, the plaintiff has not shown. The court will deny the motion as a result of the failure of the plaintiff to proceed and pursue the motion. So we will do an order, Ms. Thomas. There's nothing you have to do, and you're free to go.
Okay, Your Honor, can I just, there's something in this case that's been problematic that I just want to make sure the court's aware of, that we're not getting notice. Like, in other words, as an attorney, I'm not getting notice. She's like a text to the interveners, but like she won't tell them what the motion's about, just like a day and time. And then in
Okay.
this particular case, she switched it. She sent that, but the top part had a sticky over it, so we couldn't see what it was about. And then she sent them another text that says Coleman, May 28th, 10 a.m., not the 20th, but there's nothing on the 28th. So it's just, there's gamesmanship here and we just don't want to
Okay.
miss anything. So,
Well, I understand. We'll deal with it at some point that she comes, but today her motion's being denied, so.
right. Perfect. Great. We just want to
Okay.
make sure the court was aware. Thank
Okay,
you.
thank you. Have a good day.
You too. Bye-bye.
All right, Judge, I'm going to bring in Jalen Scott and Demetrius Watson. I do not have plaintiff Amanda Scott present. So I'm not sure how you want to handle this one. Please unmute. Jalen, can you hear me?
Yes, ma'am.
Demetrius, can you hear me?
Yes.
Calling case 2018-1593 DM Amanda Scott versus Jalen Scott with interested person Demetrius Watson. Today is Monday, May 20th, 2024 at 10:47 a.m.
Court will note that this matter is before the court on the two motions of the plaintiff to show cause, claiming that the defendants had failed to appear for the DNA testing in this matter as required by the prior order. I'll tell both of you in this matter, Mr. Scott, Mr. Watson, she is not here to proceed or pursue her show cause. So as a result, the court will deny those particular motions and she'll have to take other action in this particular matter. I don't know what it'll be, if she'll bring it back in or whatever, but she has to be here to proceed with her motions and she's not here, so.
All right.
So,
Okay.
So, Mr. Watson, if the orders change, Mr. Scott, if they change and we set a new date for the DNA, you'll have to appear and you'll have to do that. But at this point, you're not in contempt because she's not here. Okay?
Okay.
Okay. Thank you both. You're free to go.
Yeah.
Have a good day.
Interesting. Okay, so before we move on to our next set of cases, I'm going to answer Lisa's question here. So live rosin, and I think what you actually mean is live resin, but live rosin. Okay, so live refers to the processing period after cut down of the marijuana. But I've processed rosin and you have to cure it for a certain amount of time, because if you don't, it will literally be vapor, not rosin, which is what you want. And so there's like hours upon which you have to allow it to cure. But if you are using a different method, so not rosin, but creating resin, then what that refers to is usually people like freeze the weed right after they cut it down, and then they process it after it's been like frozen in time, and the flavors and stuff are really, really prevalent. That versus THC diamonds. THC diamonds are just pure THCA. So they don't have any strain effects, but they're very potent in terms of the THC factor. So a really normal and standard way of putting those together would be to dip a THC diamond into some live resin, and you would get all the flavor and impact of the live resin, but a really big impact of THC as well. Both of them are high-end, high quality products. What you want to ask is about the different processing methods. So what solvent they use to create these products. Rosin is different than resin. So rosin doesn't use any products whatsoever. It uses heat and pressure to squeeze out the concentrate from marijuana. That's the ultimate best version that you can, because other than that, you're still going to have residual solvents in your concentrate products. So if you are able and have the ability to either purchase rosin or use that or make your own, which is actually really simple, and then dab it, that would be the best concentrate method that has the least amount of particulates and dangerous stuff. Absolutely, you can smoke a bowl, of course, but for people like going to the What I don't like is when people go to the dispensary and they're sort of like sold into these things. Most average people do not need that high of a percentage. The flavoring, on the other hand, I'm all for people trying and doing different things. And of course, yeah, none of this is legal advice, and none of it's, it's all, your mileage may vary. But I ran a dispensary for a long time, and like, we couldn't sell rosin. You still really can't sell rosin to scale because it doesn't scale up. It's one of the few products in the world that doesn't scale very well. And those are actually the types of products that you find, if you can find a good supplier for them, they'll be the best ones. But they're not going to ever get very cheap because, again, it's just not scalable. Whereas when you have like a bunch of swaggy shit weed and you put it into a vessel and then you put in butane and then process it through, it really doesn't matter what the quality of the weed was when you process it like that. And that's a good thing. It's good to be able to get BHO, butane hash oil, or other types of concentrates that way. But if I can give anybody advice about how to avoid that, or like what to avoid, you want to avoid things that have been processed that much. For example, if you're dabbing and you have a dab rig, which is heated to 710 or 690 or whatever you heated it to, and you've got a piece of shatter and you hold it over it and it starts bubbling, most of that stuff is you can tell when the solvent has burned off and then it's just the concentrate left. You don't want that solvent yucky taste. It's not good. But again, none of this is very good. It's all done in moderation. Anyways, on to the next. Thanks, Lisa. We should do Weed Wednesday, really. Or I should just have a weed channel. And that way it would just be more dynamic, I guess. Okay, remove, add. Oh, courtroom 473. Where's this? Oh, there's Judgy.
Just one moment, please. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, May 20th, 2024 at 8:30 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Jason Vasquez of cases 13217DS and case 181875DP. In each of these matters, Mr. Vasquez is here today after failing to appear before the domestic relations referee on April 25th, 2024. In the first case, bond is currently set at $1,130. This is the sixth bench warrant. In the second case, bond is currently $2,073, and this is the third bench warrant. He reports that he is employed at All Pro Construction. Last payment made on these accounts was in January of 2024. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on May 29th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Vasquez, you're before the court charged with civil contempt of court due to your failure to appear in a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on May 29th, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
At the moment, not that much, sir. I was in a motorcycle accident on March 25th. It was just after the last time I was here for the court hearings. And
March 25th is my birthday. Hold on, let's start our excuse counter, buddy. Just give me one moment, please. One moment, please. 0. Perfect. Let's go. So he was in a motorcycle accident on my birthday. And let's see.
and I haven't been able to make any payments. I did get my job back. I've only been there a week and a half now. I haven't gotten my first paycheck yet, and it's a little hurting right now.
Okay, well, you do have 6 bench warrants, so of course, taking that into consideration, and you haven't paid since January this year. But being that you're working, I am taking that into consideration. I'm going to set your bond in both cases in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
200 for each, or 200 total?
200 for each.
Okay.
You're free to go, sir.
Okay, thank you, sir.
Anticlimactic. He only gave 2 excuses, really. Hi, Sean. What about
Now
this
before
guy?
the court is Joseph Brown of case 094122DP. Mr. Brown is here today after failing to appear before this court on December 29th, 2021. Bond is currently set at $3,565. This is the 5th bench warrant. He reports no employment. Last payment made on this account was in May of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on May 29th, 2024 at 8:45 a.m. before this court.
Mr. Brown, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on May 29, 2024 at 8:45 a.m. Are you able to post a bond, sir?
No, I'm not, sir.
Okay.
I'm
Yeah.
trying to get a job. I'm working with Matt Jones at the Sheriff Center. He's trying to help me get into the men's recovery or the men's life recovery program at Haven Arrest.
Okay.
So I've been trying to better myself, Your Honor, and I am trying to move forward with my life and get everything straightened out and taken care of like I'm supposed to.
Okay. Well, court does note it's your 5th bench warrant and you haven't paid in now over 2 years. So the court's taking all of that into consideration. I'm going to reduce your bond, but I'm going to set it in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
Nope.
Okay. Thank you. Free to go.
Yep.
And I have 1 bench warrant for the record, if I may.
Okay. Go ahead.
Docket 123576DS, Richard Tanner failed to appear for his referee hearing. Front of the court requested a bench warrant issue in this matter pursuant to statute.
Court would enter a bench warrant for Mr. Tanner as a result of his failure to appear before his referee hearing. Court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater. And the court would assess court costs of $150.
Thank you, Your Honor.
Okay, thank you. Have a good day.
You too.
Take care, Jeff. We'll see you Wednesday.
See you, Jesus.
See ya.
Bye, Jesus. I love Jesus so much better than whatever that lady's name is, that voice lady. Okay, we have 1 more left. We didn't watch it entirely the other day. Give me a second. I'll probably creed frame. Let's see, what was that one? 17 minutes. Oh, in 17 minutes, she says. Wait, what one was this? 17 minutes. Oh, 17 minutes. And then we gotta skim forward because we already did most of it, but we didn't do this part, I don't think.
Understanding as of the last time he was before your honor. And I have heard nothing from him. Obviously, he didn't have a chance to meet with the attorney, so I kind of wanted to know what you wanted to do with this one, your honor.
Okay. And he does want the attorney?
Yes, that's my understanding as of the last time he was before your honor.
Okay.
Well, he's not connected to the audio right now. His connection has been very unstable. He's been dropping in and out of Zoom.
Mr. Davis, can you hear me?
You should be able to hear us now, sir.
You're muted, sir. Unmute your device.
Can you hear me now?
Yes.
Okay.
Mr. Davis, it's my understanding that you did want the attorney. So what the court's going to do is adjourn this matter to June 5th, 2024 at 8:45 a.m. And you can join at that time. You'll be able to meet with the attorney and then we will proceed. Okay?
Okay.
Thank you. Free to go
Thank you.
today.
All right. Thank you.
All right, now we can go to, what was his name? Kurt Lewis. All right, Mr. Lewis, we're ready for
Yes,
you,
sir.
for your patience.
Okay.
Yes, sir.
Mr. Lewis, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses upon a first conviction. You could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, sir.
Court advised you in this matter, you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, please.
Okay.
Terrible idea. You can hear it in his voice. He knows it's a terrible idea. Sir, terrible idea. Oh my God. What's going on today? The attorney's free. You got to take the attorney. You got to take the attorney, you shut up. You take the attorney, you shut up. You take the attorney, you shut up. When the judge asks it like that, as a reminder, guys, we are not living in a movie. So it's not going to work out. It just never works out.
Are you doing so freely and voluntarily, sir?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Okay. Court will find that Mr. Lewis does freely and voluntarily waive his right to an attorney. Ms. Toff, I'm going to have you and Mr. Lewis raise your right hands. We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, I do.
Yes.
Okay, thank you. Ms. Toff, you can proceed.
Thank you. Before the court is Kurt Lewis of docket number 2011-499 DP and docket number 2012-3640 DS. We're here today on both cases for a bench warrant hearing after Mr. Lewis failed to appear before referee Fryer in April of 2014. On docket number 2011-499 DP, this case is arrears only as the minor child has emancipated. Per guideline, Mr. Lewis should be paying $551 per month. That's the guideline amount of $547.50 for arrears plus $3.50 for service and processing fees. Last payment received on this docket was $60.67 on December 22nd, 2022. This is his first show cause. He's had one bench warrant and no previous contempt findings. Monitoring compliance for the last 6 months at the rate of $551 means he should have paid $3,306 and he has paid nothing. Total arrears on this docket are currently at $38,377.56. Moving on to docket number 2012-3640DS, Mr. Lewis's total monthly obligation is $386. This comes from $255 for current support, the guideline amount of $127.50 per month towards arrears, and $3.50 for service and processing fees. His last payment received on this docket was $74.62 on December 22nd, 2022. This is his first show cause. He's had one bench warrant and no contempt findings, Monitoring compliance for the last 6 months at the rate of $386 means he should have paid $2,316 and he has paid nothing. Total arrears on this docket are currently at $43,299.39 through the month of May. Friend of the court would like Your Honor to be aware that these bench warrants were active for over 10 years and nothing was done to resolve them. Mr. Lewis did book into Calhoun County Jail on May 6, 2020.
Oh my God, it wasn't a mistake. 2014? Wow. Oh man. You know what the most disheartening thing is about all of this? The judge is going to treat him, I guess it's the good thing. He's going to treat him the same as anybody else, even though, wait, so but how do you have a withholding order, obviously, if he made a payment in 2022. And there's interesting.
24 and has credit for 9 days served.
Okay, thank you. Mr. Lewis, do you contest or dispute any of the statements made by Ms. Toth?
I do not.
Okay. Do you have any questions for Ms. Toth?
I don't think so.
Okay. What would you like to tell me, sir?
I would like to go home. I do have a job. I will make sure that this never happens again. Unfortunately, this is my fault and I apologize, but I do have a job. I just signed a 2-year lease. I do have a special needs brother at home that I take care of, and I'm willing to set up, I'll have my checks garnished. I make pretty good money.
And what do you make, sir?
I make $20 an hour. I work full time.
And where do you work at?
I'm a chef at Umani Ramen Restaurant.
And how long have you worked there?
I started the day I got in trouble, actually.
Well, when was that?
The 7th.
May 2nd?
May 7th.
7th, okay.
Last Tuesday, not a Monday. And you think that you're going to keep the job after you've been in jail for 7 days on your first day? I hope you do. I hope you have an okay night, Loud. He owes like $70K, Patrick. Like 70. It's nuts. They always just get a job.
Yes, sir.
This year?
Yes. 10 days ago.
Okay.
So I would just like to go make payments. I understand.
Okay. Let me ask you, the last year.
Yes.
Have you worked in the last year?
I have been home taking care of my special needs brother because my fiance works from home. She also just told me yesterday she was diagnosed with cancer. I don't know if that helps any.
What? Oh my God, the counter. Oh, we weren't counting. I sound so rude, but you wouldn't believe all this shit we hear. The special needs brother, the wife or the fiance with cancer. Yesterday, by the way, started a new job last Tuesday. You think you've been in jail for 9 of the 10 days, buddy? 9 of the 10 days. Are you joking? Jesus Christ. Yeah, I should make this into a video.
And I know the case with Heather Riddle, she is going to be coming in and dropping all the charges as soon as she gets back from vacation.
Well, that's fine. If she wants to do so, she'll do that, and that can clear up something. So
Yes,
that,
sir.
so that hopefully you can start making attempt at payment, because quite frankly, you owe over $80,000, sir.
Understandable. And I'm asking for an opportunity to make this good. It is my fault, and I just would like to go to work and start paying my child support, and I'll pay whatever I have to. I understand the depth of this, and I apologize for wasting everybody's time.
But the depths of this is $800 plus a month. Those are your payments. Working at the ramen shop ain't gonna do it. Right, MB? He's evaded arrest for 10 years somehow. This is crazy.
And it's time for me to be a man, and I just want to pay my child support and go home and pay my child support and take care of my business.
Have you, in the last year, have you sought out any employment?
I've DoorDash just to help. But I did realize it's time for me to get a real job, and that's exactly what I've done. And unfortunately, I'm in here and I understand the circumstances, and I would just like to go home and start paying. I mean, if we can set up a payment plan or garnish my checks, I have absolutely zero problem with that.
Okay. What's your education background, sir?
I have a bachelor's in culinary.
Okay. Anything else that you'd like me to be aware of, sir?
I think that's it. I mean, I think that's it. I was just hoping that I can go home and start paying my child support like I'm supposed to be doing.
Okay. Well, the court will make the following finding in this case that Mr. Lewis does owe in excess of $80,000. He had a bench warrant active for over 10 years in this matter, did not take care of it. That he had worked in the last year. He has not identified any jobs that he had sought out in this particular matter, notwithstanding the fact he have a bachelor's degree in apparently culinary
Yes, sir.
arts of some sort. That in fact he's well educated to be able to acquire employment, hasn't done it. That he's stayed at home. He has taken care of his brother, as he stated, to have some various needs, but notwithstanding that, he's not, again, he's not taking care of the children that he has in this particular matter. That his last payment was back in December of 2022. And as a result, the court will find that he's not made a good faith attempt at compliance. He's failed or refused to comply, and therefore he is in contempt of court. With that, anything before sentencing, sir?
What does that mean, if I may ask?
Well, I'm going to pronounce sentencing on what you have to do as far as jail time or whatever.
So there's no way that I can go home?
Unlikely, sir. I'm just giving you a chance at the allocution. So if there's anything you'd like to say.
I just asking for one more chance. I understand the depth of of what I need to do, and I have no criminal past. I don't get into any trouble, and I would just like to go home and take care of my family. And I do take care of the kids. My kids are with me half week on and week off. So
okay.
And
well, in this matter, Mr. Lewis has stated he now understands the depth, but I'm thinking to get $80,000 in arrears, there's a lot of years that you didn't understand the depth of it in this particular.
I understand that.
So, well, the court could sentence you up to 45 days in jail in this particular case.
Yes, sir.
I'm not going to sentence you to that extent, but the court does believe that a jail sentence is appropriate. What I'm going to do is sentence you to 30 days in jail with credit for 9 days served. The court is going to allow you to purge yourself of contempt by paying the sum of $500 in each case. If you do that, so the total of $1,000, then you would not have to serve the remaining time in jail. Do you have any questions, sir?
So, yes, would. So if I pay the $1,000, I can get out of here, is what you're saying?
That is correct.
Okay, I appreciate it, and I am sorry for wasting everybody's time, because I will man up and do what I have to do.
Okay. Hopefully you do, sir. Have a good day.
Thank you. I
Ms.
can go
Fields,
back
is
then?
that, you done now?
Yes, that's all for
I
me,
mean,
Your
Ms.
Honor.
Fields, this time.
Yes, I'm done with everything now, Your Honor.
I was looking at my next case.
You're good. Well, I hope you have a good rest of your day.
Okay, thank you. You too.
Take care.
Thanks. Bye.
Talk to you later. Okay, so,
Wow.
uh,
Who wants to bet we see him again?
Who has Fields?
so it was going to be Katie Platic, but
Oh,
there's
okay.
going to,
Ms. Petrulio?
are you good now?
Yeah, well, I'm on hold. Basically, you know what? I'm just gonna hang up. I had a case that I put on earlier, Jabbery Hightower, and I
Yes.
asked for adjournment to August 2nd. And
Yes.
while I was waiting for this next case, I got a message from Leap or GEMS that said he was termed due to poor attendance. We received 2 payments, and the Jabbery's response to GEMS was they must have the wrong person. So I was going to try to confirm that, but he didn't call him for his hearing. So I think I want to ask for a bench warrant on his 2
Okay.
cases.
Court would enter bench warrants for Mr. Hightower as a result of his failure to appear on today's date. Court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor. And then I'm ready for Fuller
Okay, so now we can get to.
or Fields. I'm sorry.
So we're doing Mr. Fields with you, correct?
With me, yes.
Okay.
Okay, and one moment. The
We got
custodial,
a knee in the shot.
what was the name of the custodial parent?
The
Queenie Brown.
Yep.
What's the name?
Queen. Is this a Queenie Brown, ma'am?
Queen?
Yes.
How do you spell that, please?
Queenie.
And I just lost Mr. Fields. Okay. It's coming back now.
I went to school with a girl named Queenie though, but I don't think that was her real name.
All right, can you hear us, Mr. Fields? You're still muted.
There I am.
Okay.
Yep.
Mr. Fields, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Wait, they're the couple? Are they in the same house right now? No, ceilings are different. Is he strategically showing off a US flag? Death flag? Is that what that is? Such a weird angle. And in the background, almost prominently in the shot, he has, is that a death flag? I think it is. I don't know what to call them. Ceremonial? I know there's something, but I don't know like what. Yeah, weird. She's giving dirty looks. I know she's not looking at him dirty looking, but she's like, yeah. Also, it's become an ongoing joke in my life that unintentionally almost every thumbnail that I make has a US flag in it. And even though I'm like staunchly Canadian, I accidentally include US flags all the time because I have so many pictures of judges just like this, where I include the background, and it's so funny. If you look it over, I realize I'm like, there are so many.
Yes, sir.
Court will advise you have a right to an attorney. The court would have.
Death flag sounds like the German version of it. Death status flag.
Appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yeah.
And are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence or pressure or promises to get you to appear without an attorney?
No.
Court will find that Mr. Fields does freely and voluntarily waive his right to an attorney. Mr. Fields, I'm going to have you raise your right hand, be sworn in. Ms. Petrulia has already been sworn.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Okay. Ms. Petrulia, you can proceed.
Thank you, Your Honor. This is the case of Queenie Brown versus Richard Fields. It is docket 2018 3234 DP. Mr. Fields is before the court by way of a bench warrant after he failed to appear for a show cause hearing on April 1st of 2024. He has a current support obligation of $909 a month. The arrearages are to be paid pursuant to guideline, which currently is $240 a month plus fees, for a total monthly obligation of $1,152.50. The last payment paid was $2,318.31 on December 16th, 2023. There is no bond, as he did pay $400 to resolve the bench warrant. There have been 2 show causes, 1 bench warrant, no findings of contempt. In the last 10 months, he should have paid a total of $11,525. He paid $10,188.42, so it left him short $1,336.58. The arrearage through the month of April is $12,009.82. He has no prior jail sentences. The biggest thing with Mr. Fields is that he doesn't pay on a monthly basis. He makes lump sums here and there and tries to play catch up. So, you know, kids' needs are daily, not every couple months when he can pay.
Okay. Mr. Fields, do you dispute or contest any of the statements made by Ms. Petrulia?
No, I don't dispute that I owe it. No.
Okay. Do you have any questions for Ms. Petrulia?
Not really.
Okay.
Do I explain anything or?
Yep, I'm going to give you that opportunity now. Tell me what you want to tell me, sir.
The same thing happened to me last year at this time. I had to have surgery, so I was off of work for a couple months from my neck. During that time, it basically piled up, and I was like right on the edge, just like I am now. So if anything was to happen at work or whatever, it would send me over. My boss is supposed to pay it. I don't know what happened, but I paid my child support the entire time that I worked there. Since December or since January or since the last time she got a payment, I haven't been working because he's going out of business, and I haven't been able to work because of my disability. But he has just a few different things for me left to work, and I'm getting a different job as we speak. But he sold part of the business. The business was I held grain to ethanol plants, and then when that work wasn't there, I would take the reefer trailer and go like to Florida, and so I would make gaps. So my yearly income went down for 10,000 last year to way down this year. So he's about done. I have about a week left of work with him, and then I'm starting with another company. So he was supposed to take the money out of my checks every week, and he was supposed to pay it, as it was taken out of my check. He's the one that had to pay it. I had no idea what was going on or when he paid it. The only time I knew was when she would call me and say that she hasn't got a payment, and it was basically a miscommunication between the both of us as far as when the work was going to end. And so I mean, I've been unemployed I've worked a few weeks, so I've been able to pay a little bit, and that was the money that I paid for my bail. But I got the notice on the 3rd. I just didn't check the mail. But it was just I don't know what went wrong, but I worked there for almost 4 years, and I didn't have any problems except for if sometimes it would come to a halt, or I would be off for a couple weeks or something like that, and it would he wouldn't send the payment in for like 2 months, and then he'd send like 4,000 or 2,000, but I had nothing to do with that. So I mean, I did a little bit, but what I'm saying is I'm done with this company. So the reason why the payments were stagnant like that and make here and there was because of him. I didn't know that he wasn't making payments like exactly on time or whatever the schedule was, weekly, monthly. He's
The bullshit meter is so high right now. So high.
Actually, Joy has been in contact with my boss many times and talked to him on the phone. She doesn't believe me. So he has told her that we're not working and he's going out of business, and he would like it if she would call the courts and deal with it between the courts and me. And she's been kind of harassing my boss a little bit, and it's but like I said, I don't know what the deal is, but it's over now. So the only thing I can do is move forward with this new company, and just they're a bigger company.
Well, actually, maybe the judge can throw you back in jail and you can find another $1,000. Funny how everybody finds money when they fucking get in jail, isn't it? They just fucking find money all of a sudden. Oh, imagine that. So I think, look, I have the same attitude she has. She's like, this guy's full of shit, Judge. His friend owns that company. It's just them driving around being assholes. Yeah, allegedly.
So I was the only employee there. So I don't know how it all got mixed up, but it got me behind. So and also I'm a disabled veteran, so sometimes stuff comes up to where I have to take a little bit of time off work for I have a degenerative spine disease. So but other than that, I'm just moving forward, and as we speak, I'm trying to get hired on to another trucking company so I can get all this taken care of and paid down. And I can make payments for like the last couple weeks that I work with this guy. Then I can make another payment, and then as soon as I get in with this company.
When do you get paid for these last couple of weeks that you work?
I worked last week, and then he owes me probably this Friday, and there's next week he's got like a few more loads for me to do, and he's selling the business to another farmer. So it's basically about $1,500 worth of work.
Okay.
And then I'm going with somebody else.
Okay.
So I should be starting that soon.
Okay.
Nice AirPods.
So you're gonna, let's say by next week, from what you've said, May 24th, you should have $1,500.
Well, he owes me $750 right now, and then I'll have to wait another 2 weeks for him to pay me for the next week that I work. But about $750 he owes me at this moment.
And then the following week, how much would he owe you then?
It's about the same. It just depends on how many loads that he has for me,
Okay.
but pretty close.
So by the 31st is what you're saying, that you should have about 1,500.
Yeah.
Okay.
And how much of that is gonna go towards your bills, bud? You're not giving her 1,500. She knows that too. Queenie's like, this fucking shit, Judge. This fucking shit.
Anything else that you'd like to tell me, sir?
Nope, that's about it.
Okay. Ms. Brown, is there anything you'd like to tell me?
No, sir.
Okay. Well, in this particular matter, the court does note that Mr. Fields has been making payments, although they've been sporadic. He states that it's a result of the place that he worked, and does appear that that has been the case. That in fact they've not paid him consistent as they would be required to do so. He said that basically that he has paid over the last, I don't know, 6 months or so, over $10,000 in this matter, that he has an arrearage of just over $12,000 at this time. That again, the job is closing down. He's losing his employment in this particular matter, and that he's simply going to another employer in this particular case. What the court is going to do is find that, again, he was well aware of the support obligation in this matter, that he has failed to pay as ordered in this case. I will advise you, Mr. Fields, that you have a right to seek modification of support. If in fact it is too high in this particular matter, you can file that motion with the circuit court clerk's office, and you can do that at any time to seek to have your support obligation reviewed.
Okay.
What the court is going to do in this particular matter is court cannot fail to recognize that in fact you haven't paid as ordered. As a result, you are in contempt of court in this particular matter. Is there anything you'd like to say before sentencing, sir?
No.
Okay. What the court's going to do, I do note that you haven't been in contempt previously. I could sentence you up to 45 days. I'm not going to do that because of your payments and what you've made. I'm taking all that into consideration. What the court is going to do is I am going to sentence you to 14 days in jail with credit for no time served, but I'm going to allow you to purge yourself of contempt by paying the sum of $1,000 no later than June 5th, 2024. That's the next time that we would have these particular matters where the attorney would be present. But I'm going to suspend your jail sentence in that interim time, sir. So what happens, you don't have to serve the time, but you pay the $1,000 between now and then, which is basically 3 weeks, and then you wouldn't have to serve any time.
Plus your regular payment. Judge, you're so fucking lenient.
I'm in jail. You understand?
Yeah. Yes. Is that going on my record?
On your record that you're in contempt?
Yes.
Yes, it goes on the record that there's a contempt fine. Correct.
Is that what kind of contempt charge? Is that misdemeanor or felony?
There's no, it's not a misdemeanor. It's just a contempt charge on this particular action, on the civil contempt.
Oh, I didn't know I could be put in jail for that. I got it. Okay. I understand.
Okay, so if you pay the $1,000 within 3 weeks, you don't go to jail.
And then what happens with that? I don't know. It's just a civil thing on my record. Is that what that is?
Well, no, if you don't pay it, then you have to serve the 14
No,
days
I
in
mean,
jail.
if I pay it, does it go away?
Yes,
Okay.
it resolves it, so it's done.
Oh, right. Okay. No problem. That's fine.
So Your
Okay.
Honor, just for clarification purposes, if he pays the $1,000 on or before June 5th, he doesn't have to show up in court. If
Correct.
he doesn't pay that money, then he is to show up in court and he can
Correct.
have an attorney? Or he waived his
Well, I
right?
don't know. I don't know if he's gonna ask for it at that time.
Okay,
I will this time.
okay, all right.
So presumably, and based upon what he said with the money coming in, that he would pay the purge amount, and then he wouldn't have to you wouldn't have to come in that time, and you wouldn't have any jail sentence, sir.
No problem. That's fine.
Okay. Thank you, and Ms. Brown, thank you for coming, and you have a good day.
Thank you, Your
Thank you.
Honor.
Bye.
Thank you.
Oh, I doubt she came very often. I doubt she came very often. Also, I'm pretty sure it's illegal for companies to take your money and then not pay your child support for you. Just saying. Anyways, guys, I hope that you have a wonderful evening. I thank you so much for being here. We had a great time. What else was I gonna say? Oh yeah, tomorrow we'll have the Kometz case. It's gonna be interesting. Like I said, he goes a little off the rails. It's an interesting legal case. And yeah, also reminder that I love you, I'm proud of you, and I will see you in the next video. Bye.